All right, good brothers recording.
All right, good afternoon, everybody. Some as you may know, my name is Abdul Bey. I'm honored to be with you officials of AMPAG. Very honored and very excited to give this interview. Just to give you a rundown before I ask for a brief introduction, how the interview will be conducted, there will be a series of about 4 questions, give or take, and they'll be very broad. So, as the good brother Abdul and any other officials of AMPAG who are part of this interview, such as the Minister of Foreign Affairs, would like to go back and forth. And then after we build on that one question, everybody can raise their hands and ask a question if they like to. If not, we'll just go right on to the next question. Okay. So again, my name is Abdul Bey. Abdul, good brother, if you can introduce yourself, please give a background briefly about the journey it took to get to this process and who you are in this government.
Islam, peace and love, everyone. Honors to the entire human family, honors to Prophet Noble Ali. My name is Abdul Smith Bey. I am the Wazir Al-Rais of AMPAG. Wazir Al-Rais means Prime Minister, so I'm the Prime Minister of AMPAG. The journey, it was crazy. I recall back in March, you was on that call, brother Akil, when me, you, and brother Mario Coleman Ale had an interview, or should I say a Zoom call meeting with J. Jermaine Bey and Javonde Waze Bey of AMPAC. And this was back in March. By April, they sent me about 3 different people. Isaac Bey, he's on the line now, and he's the Qazi, Chief Judge of Consular Court, as well as Amaru El Hiram Bey. He's the Hajib, or the Minister of Foreign Affairs. And one other person he sent my way, and it's been on ever since. And we had our inauguration on May 29th. And I gotta extend the credit. The third person that was sent to me, actually, she was the very first person. Her name was Empress Bey. Currently, her name, I think she's changed it to Amila Eel, but she's no longer part of the government. But for other reasons that would remain private. But she was instrumental in helping us getting through the inauguration process, which was May 29th. And so through that, with the help of her, Isaac, Amaru, and a few others that came along in the process, we established the government and had our inauguration on the 29th. And here we are 3 months later, still checking the boxes and going through our various stages of advancement as a young nation.
Islam.
Yes, sir.
All right. Yeah, that was a good introduction. So we can just go right into the first question.
Yes, sir.
And again, please feel free to expound at free will. There's no time limit to this.
Okay.
So first question I have. What are a few initial steps, or all initial steps, that must be done to create a state government?
Okay. The very first step is get on AMPAG study sessions. By study session 50, we had already established our state government. That's how solid the study sessions are. And currently he's at study session 68. There's a lot of information. When you study, follow along with the reference points. Let's keep in mind that this is not an AMPAC or J. Jermaine Bey process. This is dealing specifically with international law, treaties, and such. The instructions on how to establish a state government is in the treaties. And so to answer your question more directly, you'll find that the treaties were written by our ancestors, the sultans. And in it, they have laid out specific instructions. The main treaty would have been the treaty of the Act of Algeciras. You got to look at the preamble. In the preamble, the Sultan talks about the triple principles: sovereignty of it, excuse me, sovereignty and independence, integrity of domain, and economic liberty without any inequality. Those are your three main boxes that you'd have to check to establish a state government. Not to establish a state government, but to bring the state government to the point of forcing decolonization. So you have the establishment of your state government, and then the ultimate goal for the establishment of your state government is to force decolonization. In order to force decolonization, you got to have the triple principles in place. Those are the main three boxes. However, within each one of those principles, there's several boxes. Okay, so we'll talk about integrity. So your question is based in sovereignty and independence, which is the very first box. It's in the word, it's in the term, sovereignty and independence. You're establishing your state government. So what does it take to establish your state government? Well, there's a few boxes that you've got to check. The prophet said that he will leave the Europeans here long enough to teach us how to run government. Therefore, take a look at what they've done. Everything has got to be like manner. It's like chess, not checkers, right? So you got a king, I got a king. You've got a queen, I've got a queen, etc. Right? So they have. So let's take, for example, the territory that we have reclaimed. The charter colony formerly known as the state of Georgia. They have a flag, they have a seal, they have a constitution, don't they? So does Indiana and every other charter colonies. Well, that's what we did, was match the step of their beat. So you establish your flag, your provincial state flag, not your Moorish flag. Your Moorish flag is the East state flag, right? The flag that represents the world, really, because Morocco is the world. So you need your provincial state flag to go along with the Moorish flag. So you got your provincial state flag, your great seal. You need your constitution. That is the foundation. Without the constitution, there is no state government. So you need to establish your constitution. You want to have elections, and then after the elections, you want to have your inauguration, because what you're looking to do with the elections is establish your three branches of government: your legislative branch, executive branch, your judicial branch. And then plus whatever other positions. So, and then you get that on you do a public inauguration. Isn't that what the United States does? Don't they do elections? They do public inaugurations. And so what you do once you check off those boxes, you will compile it, right? We call it the Circle 7 state of facts, or the facts of your state, right? What are the facts of your state? Well, your Moorish flag, your state seal, your provincial state flag, your oath of allegiance, your constitution ratified, meaning that you signed it. The competent officers of your state signed that constitution in order to promulgate it and deposit it with the United Nations. And then so that's the package that you're putting together with a document called Declaration of Statehood, or a letter called Declaration of Independence, basically. And in that letter, you would highlight or point to your inauguration as a link within that letter. You bundled all that up, you send it out to the United Nations, as well as the United States of America and the United States, right? Two different entities, but the United States represents the United States of America. And then as well as the governor of whichever territory that you're reclaiming through your constitution. What do I mean by that? Your constitution will lay out the latitude, longitude of the territory that you're reclaiming, because we got to keep in mind, all of these so-called corporate states are ancient Moorish territories. So Georgia is a ancient Moorish territory. And so you reclaim it with your longitude, latitude, basically taking over the entire territory under what's called uti possidetis juris, which is an international law principle dealing with the reclamation of your states and the borders, which ultimately become international borders once you reclaim them. So currently AMPAG's borders are international borders. And I didn't get to say this at the intro, so that to make it clear for anyone who may not be aware, AMPAG stands for Allodium Moorish Palladium Ante Georgia, and it translates to Free Moorish estates before Georgia, right? So this territory was here before the corporate fiction known as state of Georgia came into existence. But back to the question. So that's what you would need to establish your state government. Once you establish your state government, which is actually pretty easy, by the way, the hardest part is to get the people together. And the prophet said that Moors are hard headed, and they are. So the key is to get some people together to establish your state of your provincial state government through the three branches of government. Once you have that established, now you're into the aspect called integrity of domain. That's where you're setting up your laws. You're fortifying your castle, right? You're setting up your national trust. You're setting up your nationality paperwork. But more importantly, you're getting consular court active with ministerial decrees that basically maintain the control of your territory. That's the integrity of domain. Then the third box would then be your economic liberty without any inequality, which is where you activate the Act of Algeciras, because that's the system that establishes your revenues for your state, which is being generated through taxes that the colonizers owe, because according to the Treaty of Peace and Friendship, that's a lease agreement, and they're tenants here, and they're supposed to be paying taxes or rent through taxes. But you don't just jump. You can't. Everything has to happen in sequential order. You can't just skip past sovereignty and independence and go straight to economic liberty without any inequality. You have to take it a step at a time, and that's essentially, in a nutshell, the establishment of a state government.
And that was very well put. And what it sounds like, before we get to the next question, what it sounds like, just to summarize it up, keep everything fresh, is that you guys created a state government, and some of the first Moroccan laws or Moroccan treaties that you have been enforcing is the Act of Algeciras.
One of three. Well, let me clarify that. It's not just the Act of Algeciras. Really, the first one is the Treaty of Peace and Friendship, 1787, 1836. The Treaty of Madrid, Article 15, Paragraph 1. Very important, because the Treaty of Madrid, Article 15, is the treaty provision that give you the authority to establish your government, because it states that any naturalized any subject of Morocco who has been naturalized in a foreign country, what's a foreign country? United States, must choose between the submission of the laws of the Empire of Morocco, right? So it's a matter of Dorothy coming back home to Morocco, right? Clicking her heels 3 times, the triple principles. it's in the movie. So after the Act of Algeciras of 1880, then you got the Treaty of, after you have the Treaty of Madrid of 1880, then you have the Act of Algeciras of 1906. So you see a sequential order in dates: 1836, 1880, 1906. That all happened within 70 years.
And just before we go into other spheres of international law, some of the important topics as far as what type of body politic, why state government, why that type of body politic opposed to other types of body politics that are not of the same value dominion as a state government. That's a very important perspective sphere to pretty much tackle, in which we'll make another video specifically for the metaphysics of, for those who don't know, but specifically for the metaphysics of international law, in which we can go into the difference between nationality and statehood, how we've been caught up in that wordplay as far as that positioning in today's international law, and just different degrees of the political science, and what we call the spiritual aspects of law. So we can, everybody can look forward to that. So more about why a state government, why this body politic, what is special about a state?
What's special about a state is that in the past 200 years, we haven't had a state, right? Now, a lot of Moors may want to say or claim that the Moorish Sign Temple of America is a state, but it's not. When we're talking about statehood, you're dealing, I mentioned uti possidetis juris earlier. You're dealing with the reclamation of a territory, which means it has to be done under an autonomous function, meaning totally separate, sovereign and independent. We're not seeking recognition from the U.S. or the United Nations. We don't have that. We don't need that. We don't need to prove that. It's already in the treaties. What we're supposed to do is just be. And so why statehood? Because statehood, the main reason why you want a state government is because through your judicial branch, you establish consular court. And consular court is the only way that we can make our Moroccan laws binding upon the colonizers. You see, we can't do that as individuals, and you surely can't do it as a standalone court. We've got too many of these things going on within the movement, too many standalone government departments without the state government itself sanctioning these departments, i.e. your Moorish consulates and your consular courts and your embassies, Moorish embassies. There's all these things that exist within the Moorish movement that requires the sanction of or the backing of a state government. You understand? It's even in Article 20 of the Treaty of Peace and Friendship, where it states that if there's a dispute between a citizen and a Moor, consular court gets to decide, and the government is supposed to back consular court in their decision. That's in Article 20. This is what we mean by instructions. The articles, the treaties, and the provisions in the treaties lay out the instructions for us and the things that we need to do. So why statehood? Because you need consular court, and consular court is the only way to make our Moroccan laws binding upon the colonizers. The judges of the ICJ reaffirmed that on page 202 of the ICJ case concerning nationals. Listen to this title: Case concerning nationals of the United States of America in Morocco. That's the title to the case. Mm-hmm. So page 202 lets you know that in that way and in that way only can the laws be binding against the colonizers, is through consular court. So that's the main reason why you need a state government, is because consular court is where you exercise your powers.
Right. And just to expound just a little bit on that before we get into this next question, which is similar to this question or this topic. But a lot of Moors, and the reason why I asked that question is because a lot of Moors have been getting mixed up or confused as far as actual government and organizations that are theocratic governments or other types of organizations. So therefore, some Moors get tangled up as far as setting the line, deciphering the line between the two arenas.
Right.
So, there's a good book. It's called the Vaina Law on Treaties. It's a commentary. And it's a great book to expound on, again, the Vaina Law on Treaties, which is the treaty of all treaties.
Yeah.
And so to basically understand how the United Nations or international law, period, in any sense, how it's to operate, that would be a good book. It's a commentary to understand the basis of everything, in which it expounds on. It's a decolonization process, as you said, and much more.
Yes.
So the next question is, what are some common misconceptions within the Moorish community that need to be addressed in order for Moors to understand international law?
Enforce the Constitution. Enforce the Constitution. Enforce the Constitution. Enforce the Constitution. Right. Enforce the Constitution. Why are we enforcing their Constitution? It's because we're too lazy to write our own Constitution. We gotta, come on. We're Moors. We are the heirs of the land, correct? So if we're the Moors and we're the heirs of the land, the sovereigns of the land, why are we utilizing their laws for our salvation? That's just nonsensical to me, good brother. with all due respect to all the Moors out there who's doing that, because of keeping it real. I've done it myself. You know, I went to RV Bay Publication, downloaded the name corrections and all that, sent it to the 7 locations, got my nationality card, and it worked until it didn't work no more. Right. So if I'm saying that you have no jurisdiction over me as a colonizer, then why am I turning around right after that and telling them to enforce their constitution and invoking their laws? That's one huge misconception, misinformation that's got us in a trick bag. Because what we're supposed to be doing is enforcing treaties, not enforcing their constitution. The only thing I care about their constitution is Article 6, which states that treaties is the supreme law of the land. Well, then if treaties are which was written by our ancestors, by the way, so if treaties is the supreme law of the land, then why are we talking about your constitution? No. Here's our constitution. There's your constitution, United States. So our constitution is called the Law of Sankofa. So here's the Law of Sankofa versus the Constitution of or for. It doesn't matter whether it's of or for the United States of America. It's still their constitution, right? So the Law of Sankofa versus the United States of America's Constitution cancels each other out. Why? Because now we're on equal footing. We're on equal grounds. I'm no longer stateless without a constitution, begging for you to enforce your constitution, which, by the way, they have been enforcing the constitution and the treaties upon us. So now we've got 2 constitutions, ours and yours. That gets voided out. If that gets voided out, what takes over? Treaties, international law, the Treaty of Peace and Friendship, 1787 and 1836, that gave you the existence, that even gave you the recognition as the United States of America to have the sovereign authority or the sovereign capacity, I should say, to operate as a sovereign nation within our land. But you have to pay rent. So that's one of the main misconceptions that we're dealing with, is all this enforced constitution. It's absolutely incompetent. With all due respect to my Moors out there, it is absolutely incompetent. We are supposed to write our own treaties, our own constitution, enact legislation, establish our own state governments. The prophet said he's going to leave the Europeans here long enough to teach us how to run government. Why? Because the colonizers learned how to run government from us. In the past 200 years of the coma, or being buried in a shallow grave in the West, we've lost that understanding. How do we regain it? Study the Europeans, because they got it from us. And they, under the Articles of Confederation, they wrote up their constitution, gave it to the Sultan to accept. He accepted it, right? 1789, George Washington revised that constitution, dissolved that government, which is the Articles of Confederation, and established the United States of America and its constitution. You'll find it. He thought proper. Are you there?
Yes.
Okay.
Yep.
Okay. I got kicked out. My internet kicked out.
Okay.
He thought proper to write a new constitution agreeable to the sultans, right? And then he sent it to the sultans, Sidi Muhammad. This was in 1789. The letter of George Washington to the sultan. So why are we enforcing their constitution when we had a constitution here prior to their constitution? Their constitution only came into existence in 1789. We had a constitution long before that. So that's the main misconception that we're dealing with, that we really need to shake that off and start really focusing on this, on enacting our own constitution, and stop being worried about what their constitution is doing or not doing. Islam.
Yeah, that's definitely a very, very heavy misconception right there, and that even behind that statement itself leads to more understanding on that topic alone, and understanding that the term Moorish Americans, all of this, dash African dash American, Italian dash American, how substantial are these topics? They're not too substantial. And so, just as you said, You know, we're not trying to bash anybody, but once we say the words incompetent versus competent, well, in international law, competency means full powers, simple and plain.
Yeah, right.
So, and you can read that in the book, the Vaina Law and Treaties, the commentary book. And so when we say competency, we're not talking about your common sense as a being. We're talking about international law, period, strictly.
Correct.
So, you know, right. So don't take this as a shot or nothing, but we have to understand the psychological tricks, the psychological walls that have been placed, because let's think about how infiltrated the temple or any other organization is if you know, things like African American, Italian American, then we have Moorish American, that's nowhere to be found in any treaty if all law is specific or if Allah is specific, right?
Yeah.
We have a treaty between Americans and Moors. Well, Moorish Americans, that's two different governments you just brought together, in which there's no treaty that binds the two governments.
What, Moorish American, the Moorish American? Well, there is a treaty that binds the two governments. That's the reason why it's.
Well, I say citizenship clause. I say that.
Okay, because you know it's between the Treaty of Peace and Friendship was between the United States of America, the Americans, and Morocco, the Moroccans.
Right.
So calling yourself a Moorish American is taking both sides of the contract. You're calling yourself two nations, no different than calling yourself two continents, African American. So when you say Moorish American, you're calling out, you're taking on the jurisdiction of two different jurisdictions. You're taking on the identity of two different jurisdictions, two different nations, the Moroccans. Now, but what's the difference between the Italian American versus the Moorish American, or the Portuguese American versus the Moorish American, right? The difference between all those other political statuses versus ours is that according to the treaties, according to what our ancestors have laid down on paper through legislation, we are not citizens. Our Moroccan laws was never based in any form of citizenry. We're subjects. Either you're the subject of Morocco or a Moorish subject under the jurisdiction of another power. So when you're saying you're a subject of Morocco, that means that you're subject to the crown of Morocco, right? But within as a subjugated people, we fell under the jurisdiction of the United States because they claimed us through the Naturalization Act, right? But prior to that, to them claiming us through the Naturalization Act or adopting us against our consent, we would have been known as Moorish subjects. So we're not citizens, never have been. What they did was they put us in a trick bag by establishing the what is it called, the Act of Congress, the Naturalization Act of 1790, I believe it was. But see, this is the reason why Dred Scott was found as a plaintiff in error. Why was he found as a plaintiff in error? Because Dred Scott was not a citizen, which means he could not petition. He could not petition the United States Supreme Court for to solve his what's the word I'm looking for, to get remedy from the courts. He couldn't seek remedy from the United States courts because he wasn't a United States citizen. This happened in the 1755, 1757, I think it was. I believe it was 1757. Please go back and do your research on that. I think it's 1757, the Dred Scott case. But my point that I'm trying to make is that at the time we were more subjects. That's why he was found as a plaintiff in error. Why? Because he was supposed to petition consular court, not the United States Supreme Court. But now, if these Negroes would recognize or know consciously, the same way the average Black person consciously believes in themselves as Blacks, Negroes, colors. If our conscious understanding of our political status was Moorish subjects, and we knew that consciously, we would have solved this problem a long time ago, because it put us in the proper political status as Moorish subjects. And so now with that understanding, we would say, well, why are we Moorish subjects? What do we need to do to fix this? And we would be questioning it properly. to then identify and recognize that it's consular court that we needed for our remedy. So they said, oh, hell no, we can't have that. And so they turned us into citizens to take us away, further away from Morocco and consular court. And then guess what? The Sultan said, oh, y'all want to play these games? You want to naturalize our people? Okay, here's Article 15, paragraph 1 of the Treaty of Madrid. We'll go into that later. But just to answer your question quickly, or to go into that, that's the reason why, like the Italian Americans, they have a different status because they are citizens. We never were citizens. We were only Moorish subjects, which means we always had the opening to go back to Morocco because the land that we're sitting in is Morocco. It's just that we're dealing with extraterritorial jurisdiction in which the United States, or the Americans, the foreign Americans, have encroached upon our jurisdiction, upon our borders through extraterritorial jurisdiction under legal, through legal means. Why? Because we acquiesced, and there was no Moorish, competent Moorish government in place to reject their position or challenge their position. We acquiesced. We was buried in a shallow grave, and we just remained buried and allowed them to carry on the show. Islam, I yield the floor.
Yeah, that was well said. Well said. And just a highlighted point that caught my mind when you were speaking. There were two Moors within this past month that had brought up the points throughout several conversations that the sundry free Moors, the point they were trying to prove was kind of, just a little bit off topic, but the sundry free Moors, their point, it just, as a lot of other Moors think, the sundry free Moors petitioned, right? Mm-hmm. But we got to understand who the realm of petitioning in that time, petitioning to the Sultan. Well, in today's time, it's not in international law. It's not set up for us to petition the Sultan if the Sultan has already created a state government called the Kingdom of Morocco. So if they're third parties of a whole different type of government from ours, there'll be no sense in petitioning to another government that's not a part of ours, right? They're both third state parties. So there would be no point. We have to understand the history of not only Moors as a whole, but the history of international law more specifically, and the weight of how what we know has happened, how it has changed the international law arena. And these are
You also got to look at the timeline. The Sundry Free Moor was in 1790.
Right.
I mean, it was in 1790, right? The final drafting of the Treaty of Peace and Friendship was in 1836. What is that telling you? Morocco was still in existence, right? The Sultan was still sitting on the throne. But today is 2022. We can't, that's apples to oranges if you want to use that particular case, because today there is no Sultan. The Sultan has demoted himself to king, like you were saying, and became the king of the kingdom of Morocco over there across the water in Al-Kiblan. So right now, and in doing so, he abandoned the empire. So the empire is laying dormant. There is no Sultan. There is no governing body that's governing and operating Morocco. So therefore, we don't have any remedies. But the Sundry Free Moors did, because the empire was still rocking and rolling. I don't even know why we bring that up as a case, because it's totally nonsensical for us. Because again, the Sultan was in power at the time, or the empire was in power at the time. Currently, in this day and age, it's not, and that's the purpose in AMPAG, New Mecca, and AMPAG coming together to bring Mother mother Morocco out of her 200-year political extinction, her 200-year coma that she's been in. And it hasn't even been 200 years, really, because, like I said, the Sultan came, switched his allegiance or switched his the structure to become the king in Morocco and Al-Kibilan. But it still was in existence from the perspective that the melanated, the darker, the original, the Aboriginal and indigenous Moroccans, not Aboriginal or indigenous American. There's nothing of Aboriginal or indigenous or ancient about the term America. Morocco is ancient. The prophet said that the flag has been flying over here over 10,000 years. Not America. We got to get that together. So anyhow, I lost my train of thought. I think what I was saying is that as the heavy melanated Moors or Moroccans of the land, we haven't been in power as the governing body for the past 200 years. The Sultan that left Morocco and the empire and went to the kingdom, he was, he wasn't necessarily phenotypically equal to us, right? He was more of a light-skinned Arab type of guy, just to make that clear.
Yeah. So it, that point also leads me into another sphere that I see going on as far as solutions, how Moors should go about finding solutions. And this specific solution is a letter of rogatory.
Right. Okay. Yeah.
So if you would give me a second, I will go to the images that I have, and then I'll screen share them. Okay. And that way we can read straight from it and read exactly what it is. So we're not saying anything,
Yeah. We want to have reference points for the points that we're making. Islam. I don't know if I have to give you the ability to share. Are you able to share without me giving it to you?
Yeah, it says it gives me the option. Oh, no, I can't. Nope. Only the host can share it in this meeting. Well, I'll just read straight from the article then.
Okay.
Okay, so and you may not be able to see my face because I'm off screen, but on law.cornell.edu, right? This is Cornell Law School. This is what's defined as letters rogatory.
Hold on a second, good brother. I don't mean to cut you off. Try to share now. See if you can share now.
No, it still says only the host.
Okay. All right, go ahead, brother. I'll try to fix it for you.
It says, in its broader sense, in international practice, the term letters rogatory denotes a formal request from a court in which an action is pending to a foreign court to perform some judicial act. Examples are requests for taking of evidence, the serving of a summons, subpoena, or any other legal notice, or an execution of a civil judgment. Now I will go to another screen share I took and read from this. It's basically the same thing, just worded slightly different. What is the purpose of a letter of rogatory? A letter of rogatory is a request from a judge in the United States to the judiciary of a foreign country requesting the performance of an act which, if done without the sanction of a foreign court, would constitute a violation to that country's sovereignty. So obviously, there's two courts already active and at play. you send one, you request, you send this letter of rogatory from the United States to another foreign court, which should already be active, right, in order to receive it.
Mm-hmm.
And the procedure will go as the law takes place, right?
Yes.
In which there has to be another court established or another state government established to have a court.
Yeah.
So can you expound on how this could or could not work? Can this even work, right?
Well, okay. You know me, I have a problem sugarcoating stuff. So that whole letter of rogatory thing comes from Abdullah and Shem, right? Um the ICJ judges, the 15 high-level judges said that the only way that Moroccan laws can be made enforceable against the United States is through consular court, and in that way and that way only. I'll draw your attention to Article 20. Let me share my screen. Oops, let's see, basic. All right, let me share the screen. All right, can you see the screen?
Mm-hmm. Yeah, I can see it.
Okay, let me go to. All right, let's go to. What is this thing here? What is this green box? That green box is bugging me out. Genie. All right. This is it. This is it. I don't know what this. Do you see this green screen on my screen? This green square? I don't know what that is.
No, I can't see it.
You can't?
No.
Okay, maybe it's just me on my end. Okay. So what I pulled up is a treaty of peace and friendship. And I'm gonna read Article 20. You guys can follow
It's not
along.
showing the whole thing though.
Okay. I don't know what's up with this. Hold on one second.
It's showing like most of the sentences. We can't see the beginning or the end of it.
Let me stop sharing and then let me share again. Because for some reason it's bringing up this little screen portion. Screen share. See, it keeps giving me this box. I don't know why it's giving me this box. Hold on one second, brother. Let me try to. I gotta get it. I gotta get it on the screen. I don't know why it's giving me that green box. Same it. Come on, work with me, computer. Okay. Screen. Okay. Let's see. All right. Now we can. Okay. Can you see it now?
Yep.
Okay.
Okay.
All right. So Article 20. It says, if any of the citizens of the United States or any persons under their protection shall have any disputes with each other, the consul shall decide between the parties, and whenever a consul shall require any aid or assistance from our government to enforce his decision, it shall be immediately granted to him. You understand? So what that's saying is that if there's any disputes between us and them on whatever level, whatever capacity, consular court comes in and makes the final decision. Consular court has the authority to adjudicate that case. Consular court has the authority to make a decision based on this dispute. And our government, through legislation, must back his decision or the judgment that came from consular court. I didn't read not one thing that says anything about no letter of rogatory on there now, did I? Okay, let's try another one. Let's try another one because I'm coming with reference points. I'm not just gonna speak on it without showing something. Okay, let's go to this is the question that you asked the other night, good brother. I got so many tabs. Where is it? Where is it? There we go. No, that's the French protectorate. Passing of the empire. Okay. All right. Right here. So what I'm going to quote, I'm going to highlight what I'm reading. This is what I'm reading. Can you see that, good brother?
Yeah.
This is the ICJ, International Court of Justice. And they were talking about the United States was trying to make a point, trying to make the case that we're supposed to get permission from them to establish our governments and to enact Moroccan laws based on what they were claiming to be the right of assent. Well, the ICJ kicked that out because it said that there's no provision, there's no treaty provision in existence that says that the Moors got to get permission from you. What are you talking about, United States? You got that twisted, United States. This is the ICJ talking to the United States. So then they came. So this is one of the things that they said in that judgment. In the absence of any treaty provisions dealing with the matter, it has been contended that a right of assent can be based on custom, usage, or practice. It is unnecessary to repeat the reasons which have been given for rejecting custom, usage, and practice as a basis for extended consular jurisdiction, and which are largely applicable to the right of assent. It is, however, necessary to point out that the very large number of instances in which Moroccan laws will refer to the United States authorities can readily be explained as a convenient way of ensuring their incorporation in ministerial decrees binding upon the consular court. In that way, and in that way only, could these laws be made enforceable as against United States nationals, so long as the extended consular jurisdiction was being exercised.
Hey, you starting to break up a little bit.
Can you hear me? Can you hear me better? Can you hear me?
Still sound a little choppy. Still choppy.
I don't know, but I got full internet access. It's all chopped up. It's all it's all frozen. Goodness gracious. Hold on a second. Let me. Goodness gracious. Give me 1 second. Let me see if I can fix this. I don't know what's going on.
And you look from the Wi-Fi, and plus it's still.
I know. Stay right north of here. Can't even go.
Wait, I think you may have just got clear. Yep.
You could hear me better now?
I can hear you now. Yep.
Okay.
Can you hear me?
Yeah, I can hear you. But it's still kind of like choppy and weird.
Okay. Yeah, I can hear you clear now.
All right, I can hear
you
clearly now. Just a little
bit. Yeah, just a tad bit.
All right.
Okay.
Yeah. All right, can you hear me? What about now?
Yep. You clear, 100%.
Okay. Oh Lord, I don't know what that was. This is annoying, man. I hate it when it does that. Okay. All right. So, all right. I'll finish. Let me. Okay. Which have been given for rejecting customs. Your internet connection is unstable. Can you hear me?
Yep.
All right.
I see the screen too.
You can see the screen too?
Yep.
Okay, good. All right. Okay. For rejecting customs and usage and practice as a basis for extended consular jurisdiction, in which are largely applicable to the right of assent, It is, however, necessary to point out that the very large number of instances in which Moroccan laws were referred to the United States authorities can readily be explained as a convenient way of ensuring their incorporation in ministerial decrees binding upon the consular court. In that way, and in that way only, could these laws be made enforceable as against the United States nationals, so long as the extended consular jurisdiction has been exercised. Did you hear everything that I said?
Yep, nice and
Okay.
clear.
All right. So basically, what it's saying is that right now consular court is not being exercised, but as long as consular court is being exercised, then the Moroccan laws can be made binding upon the United States, and that way and in that way only can it be that way. Can we utilize can we enforce our Moroccan laws against the United States, which is through consular court? So I pointed out those two uh, that case law and the treaty provision of the Treaty of Peace and Friendship to show and prove. First of all, you don't see letter of rogatory nowhere in neither one of these documents. That's number one. And number two, the ultimate authority for the exercise of Moroccan laws dealing with the colonizers comes through consular court. Not a letter of rogatory or whatever else people want to make up. I'm not really sure. That's nowhere in the treaties, or at least not any treaties that I've read.
Right. And that's pretty much what
I lost you, brother. Are you there? Are you there?
Definitely had to. Yeah, can you hear me?
Yeah, it froze. Okay, now I could hear you now. Go ahead, good brother. Say what you were saying.
Yeah, I was just saying, it's just definitely time to stop with the self proposals.
Yeah.
And just go strictly what it says in our own international laws. And there's nothing, there's no wheel to reinvent. There's nothing that we have to hurry up and come up with, out of thin air. Everything is in the laws. All the instructions are in our laws.
That's correct, good brother.
In which that we can tap into the spirit of the United Nations itself, because along with that, the letter of rogatory idea that was proposed again by Abdullah and Shem and others in that camp. Mm-hmm. These ideas are not following Moroccan laws, first and foremost. For two, when it comes to the United Nations, and good brother, you can heavily expound on this, being that you guys were one of the first Moorish states to come online. As far as the United Nations, some Moors believe that you have to be a part of the United Nations in order to have a state government. Some Moors believe that you have to take some type of binding agreement that leads you to be subject to them, or leads you to be what they say back to slavery. So can you expound on how us as Moors can de jure not be a part, or do we have to be?
You don't have to be a part. I mean, you can be a member state or a non-member state. AMPAG, New Mecca, and AMPAG, we're non-member state governments with the United Nations, but we're not with the United Nations. People have a misunderstanding and a misconception of what the United Nations is. The United Nations is just like a middleman or a referee on behalf of the nations of the earth. So an example would be when you ratify, promulgate, and deposit your constitution with the United Nations, you're not seeking recognition from them. You're not looking for nothing from them. I'm a Moor. I'm a Moroccan. And basically all of international law is based in Moroccan law. The United Nations is not even a state, it's an organization. That means that AMPAG, and NUMECA has sovereign authority over the United Nations because they're just an organization. Also, same as other nations across the world. The sovereignty is found in the people, not the United Nations. So what is the purpose in promulgating and depositing your treaty or your constitution with them and your declaration of statehood? Well, there's 193 nation states, member states of the United Nations, right? Right? Can you hear me?
Yeah.
Okay.
Yeah.
All right. Well, okay. Well, then you have a choice. You can do it one way or the other. You can acquire 193 stamps, 193 envelopes, right? 193, print off 193 different documents and send it off to all 193 other member states. Or you can deposit it with the United Nations, and their job is to let all the other 193 states know that you have come online as a new sovereign state. Take your pick.
Right.
Can you hear me? It feels like it froze up. Okay.
Yeah.
All right. So that's the reason why you want to deposit it with them. It's the same process. It's the same Moorish American process. Don't you have to put people on notice when you do things? When you do your name correction, don't you have to put it on the record with 7 different locations, the Secretary of State, etc.? Okay, then. So that's just part of law. You got to put it on the record, let everyone know that you are in existence. And that's the purpose of the United Nations. One of the purposes of the United Nations in regards to depositing your treaties, or should I say your constitution, is not seeking recognition so that they can do their job, which is to inform the other nations of our existence coming online. So there's